Hi, friends. How are you all doing? Welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. I'm your host, Mercy, and I'm glad connecting with you on this platform. If you're yet to subscribe to the channel, please do consider subscribing. Click the subscribe button, share the video to others, also hit on the notification bell so whenever we drop a new video, you will be notified. We have great content on the channel. Please do well go to the channel. You'll be so glad you met us or you have found our channel because what we share is premium content with excellence aimed at helping you becoming better in your studies if you're a law student, in your practice if you're a lawyer. We just want you to understand law concepts in the most simplified form. So today we're looking at voluntary revocation of a will. Now, when a will is made, it can be revoked by the testator, either voluntarily or involuntarily. So today we're just looking at the voluntary revocation of a will. How can a testator revoke his or her will voluntarily? Now, when we talk about revocation of a will, voluntary revocation of a will, we're looking at Section 20 of the Wills Act. Now, there are ways in which a testator can validly revoke his will voluntarily. So the first way is executing another will or using a codicil, where a testator made a will and subsequently executes another will or makes a codicil. You know, it revokes the will that was earlier made. Now there are conditions for this to stand. Where there is a revocation clause in that will, if there is a revocation clause in that will, it suffices. It can be used to what revoke that will. Now, it also depends. The revocation of a will by using another will or policy will also depend on whether the testator knew and approved the revocation clause. So, when there is a revocation clause in a will, does the testator know about it? So, it's also a consideration when uh, you're talking about revocation of a will voluntarily. Now, we also look at whether the terms in the new will are consistent or constant with what was in the previous will. Are they materially inconsistent with the terms of the previous will? So these are also the considerations when a will is revoked by executing another will or using what a codicil. Now, when there is a revocation clause, it raises that presumption of intention to revoke, and it demands a lot of evidence to report that presumption. Now, we have express revocation and implied revocation, where a will contains a revocation clause and it revokes, you know, an earlier will. That's what we mean by express revocation. We also implied revocation also comes to play comes to play. For example, where a testator who had made a will whereby he disposed his properties and he later executed another will or a codicil in which he disposed same properties to either different beneficiaries or in a manner that is inconsistent with how he disposed it in his former will. So that is implied what revocation. So we have express revocation, we also have implied what revocation. So one of the ways you can voluntarily revoke your will is by executing another will or using the word a codicy. And we have listed what you have to look out for, whether there is a revocation clause or whether the certain knew and approved the revocation clause, whether the terms in the new will are materially inconsistent with the terms of the earlier or the previous will. Very, very, very important. So another way you can voluntarily revoke your will is by a written intention to revoke. The written intention what to revoke That written intention must be from the word testator, conveying his intention to revoke his will. Now, for this to stand, what does the law require? The law requires that for there to be a written intention to what revoke, the statement must be in writing. It will not need to be oral. The intention to revoke, the statement must be what in writing. Then there must be what we call the revocandi. Animus revocandi. That is the intention to revoke the will. It has to be there. The intention. Does the testator have the intention to revoke his previous will? Also, the testator at the time of revoking the will must have what we call the testamentary capacity to make that statement at the time of making it. So, does the testator have the testamentary capacity? The statement showing the intention to revoke must be signed by the testator, and it must also be executed, or it must be witnessed by at least two witnesses. Beyond being executed by the testator, it must also be attested to by two witnesses. The statement showing the intention to revoke must not have been made by under duress, by mistake, or by fraud, or obtained by fraud by any other person. Now, another way you can voluntarily revoke your will is by destruction. Now, revocation by destruction goes together with intention, because you must have that animus revocandi, which is the intention to revoke. A will can be revoked by a testator or another person in his presence at his direction, either in burnt, by tearing, or destruction. Now, when we talk about revocation by destruction, there are very key dominating factors that must be considered. The acts of destruction, the intention to revoke, and the acts of what destruction must be contemporaneous with intention to revoke. What this means is that the act of revocation must be contemporaneous with intention to revoke. The two must come together. You want to destroy and you have the intention to destroy. Not that you want to destroy, but there is no intention. So the two must come together, must work together. Those acts of destruction must go in with the intention to what revoke. So these three factors are the dominating factors when you're talking about revocation of will by destruction. The acts of destruction, the intention to revoke, and the acts of destruction must go together with the intention to what revoke. Now, when we talk about destruction, in terms of burning the wheel, tearing the wheel, it has to be complete. You can't just squeeze the wheel and say it's been destroyed. Squeezing does not stand for standing under destruction of wheel. It cannot fly. Or where you say you just use a line and draw on the wheel to say it's been destroyed. No, it's not been destroyed. The destruction must be complete. So a wheel can be destroyed in part. Where a part, for adventure, where a wheel is like 10 pages, you destroy 3 pages. That is destruction in by of a part of that wheel. So destruction can be part destruction and also complete or full destruction. This is where the whole wheel is destroyed either by tearing it, burning it, and the destruction must be what sufficient or complete. It must not. It does not feel like symbolic. You want to destroy the whole, you just burn one piece of it and say it symbolizes the whole destruction. No, there's nothing symbolic in the destruction. It has to be complete. Squeezing it, obliterating on it, ruling lines on it does not show complete what destruction. You must also know that cancellation of will is different from revocation. When you're revoking a will, it has to be complete. Either you're revoking in part, let us know you're revoking in part, or your revocation of the will is full. So you have to know what you're doing. And when you're advising your clients, also advise them well. If they are revoking, they are revoking. They're not like revoking. If you're revoking in part, let it be known you're revoking in part. If you want to destroy, you destroy. Now, a will can also be destroyed by another person, but it has to be by the instruction of the testator and in the presence of the testator. Very important. At the instruction of the testator, in the presence of the what? The testator is very, very, very key. Where a will is destroyed by another person without the instruction of the testator, it will not be a valid revocation. So where someone else destroys a will for another person, it has been at the testator. It has to be in the presence of the testator and by the instruction of the testator. Now, the considering intention to revoke very is very key. The animals revoke and die for intention for you to be validly utilized, for you to be valid, for the intention to be valid and legally effective. It must be a conscious act. It has to be a conscious act. Now, there are circumstances where intention will not be inferred. Where someone destroys a will and you look at it, you consider the intention. If these things are there, then that intention will not be inferred. Drunkenness. Where a testator is drunk, you cannot infer his intention to revoke his will. So when someone is in a drunk state, you cannot say in that state the person had that intention to destroy or revoke his will. Where there's mental issues, insanity, where a will is destroyed by a testator when he's mentally unstable, it cannot be a valid revocation. So a will that is destroyed by a testator in a state of drunkenness, in a state of insanity, cannot be taken as what? Illegal revocation. Accidental destruction or by mistake, where a house got burned, where someone was trying to destroy other things and destroy it, where the testator destroys the will either by mistake, either of fact or law, that will remains what? Valid. So if it's an accidental mistake, accidental destruction, that will remains well valid. So it's important to understand the gravity of what? Intention, which is the animals revoke and die, is very, very important because it works together with the acts of destruction. If the person destroys it, is destroying his will, is drunk, insane, accidental destruction, mistake, then you cannot regard it as a valid what? Destruction. Where a testator obliterates or rules on his signature, kind of or rules a line, kind of uses a pen or a pencil to rule on his signature to cancel it. It's like obliteration. And there is no evidence to show why it was done and the purpose. The will still remains valid. So obliteration of signature without clear evidence of who and why it is done does not what? Revoke, does not stand as a sign of revocation of a will. So the testator must be in a clean state, must be aware of who he must have the testamentary capacity. Now, there's something we call the presumption of revocation. Revocation. I'll talk about the presumption of revocation in another video. I just hope you've learned something about voluntary revocation of a will. We looked at the instances, we looked at the requirement on each of the subheads, and I just hope you'll be able to pick one or two things from this video. And when you're advising your client, when you're in a position to advise or you have a case on someone claiming our father's will was revoked, our father revoked his will before he died, our mother revoked her will before, all these issues. So these are things you look out for to, in bringing out the questions you ask the witness, in understanding the situation and knowing what the law say on these issues. If you're yet to subscribe to the channel, don't forget hitting that subscribe button. Thank you for listening, and I do know that you will be blessed and you become better than you have ever been. You can be the best just about having having you know that trust in yourself, believing yourself that you can make it. Empower yourself, do all you can to improve your knowledge, because the higher you go, you know, the tougher it can get. But with knowledge, you can what pass through any challenges you're going through. You can be the best, because the sky can only be your stepping stone, not even your point of destination. Thank you.